Hello, my name is Marcin Kozik, and I'm a director and a founder of KA Law, a company providing specialist employment law advice and employment tribunal representation for employers and employees. And today I wanted to tell you briefly about the concept of unfair dismissal. Well, this right is set out in the Employment Rights Act 1996 and states that an employee should not be unfairly dismissed. I wanted to focus today on the principles concerning cases involving allegations of gross misconduct or misconduct. Because the statute is silent on the issue, the employment tribunals will have to follow guidelines that have been worked out by the upper courts. And here the most important landmark case is called the British Home Stores versus Birchall. In this particular case, the Employment Appeal Tribunal said that the employment tribunals should have regard to four circumstances. Number one, did the dismissing officer hold a reasonable belief in employee's guilt? Number two, was that belief held on reasonable grounds? Number three, was there a fair and reasonable investigation into the offence? Number four, did the decision to dismiss fall within the band of reasonable responses? I'll start with number four. Well, this is really a question of proportionality. The tribunal will look as to whether or not any other reasonable employer would have dismissed for a similar offence. So, for example, in cases concerning theft, a sanction of dismissal will almost always be a justified sanction, whereas in cases of lesser offences, it might not always be the case. With regards to number three, if you haven't followed due process, which is normally a precondition for any belief or reasonable belief, you might find that the tribunal will make an adverse finding. So, in addition to certain procedural requirements that are set out in the ACA's Code of Practice, you should really make sure that you reasonably securing and assessing evidence available to you. So, for example, if you are relying upon a witness that was distant to the situation in question or has some personal vendetta against your employee, but fail to secure and see CCTV that was present on the scene, you are risking that the tribunal will say that you haven't followed fair and reasonable investigation, and then an adverse decision of unfair dismissal will most likely follow. Also, the tribunals will not try to substitute their view with the view of the employer, you. There are some questions related to contribution, which you might argue in the tribunal. So, for example, if your employee contributed to the offence in question, you might ask the tribunal to reduce the compensation accordingly. In a case of Polki, this is a case that was determined by the House of Lords. It was said that you might avoid a finding of unfair dismissal if you convince the tribunal that you would have dismissed regardless of whether or not you followed a fair and reasonable investigation. If you have any questions about this somewhat complex legal issue, please do not hesitate to contact us at info@klaw.co.uk or give us a call at the office 01727 568 083. Thank you very much.